just to say, most of you, I think, know that you've used us up and killed us this week. And we're dead and we have no energy. So we get replaced by replenished, energetic, smart, loving, caring people who will be in next week. And we just want to thank you guys for what's been a great week for us. And we wish you very well.
Next week, they're the B team.
Sure. And let me just send out thank you for the JAG for coming to this program. It was our first year. Just
remember, you were two lawyers. You're the lawyers that you were before you came here, and you're the lawyers that you're going to be when you leave. We'd like to hear from you. If you have successes, it's important to let us know that what you find. I've done this. I've done something that I've never done before. We want to hear that because when you leave here, you know, you're to cross-pollinate so many other people. Dirty vessels, all right. Trying to make a poignant moment. All right.
That's any gravy or a mixed sample.
Not the baby daddy.
Anyway, it's important. It's important for us to hear back from y'all, for you to share with us how it's going, and you'll have all our information too for all the faculty for 2 weeks, email addresses, phone numbers, whatever you need. Call us. We're happy to help you because it's. I think I can speak for all this. This group as a whole has shown a real desire to want to learn and want to get better, and that's why you came here. And I appreciated everybody, the section that I went through and talked to, efforts, and I know it's going to be a long week. By Tuesday next week, I mean, you heard them right now, and the faculty's coming in Monday, and they're happy, they're playing, they're ready to go, and you're going to be looking at them going, stay away from me. Right? But power it through, and it'll be fun.
if you didn't write it down yesterday, My Little Red Rules Book app. My Little Red Rules Book app, $6.99. Rules of evidence, and it hyperlinks to all the cases. Oh, there it is. It's this in an app, and it is so cool. How many of you have downloaded it already?
What's the name again?
My Little Red Rules Book 2012 app. You got it, Joe?
I've got it. I think I have it.
All right.
Freaking cool.
It is
I
so.
didn't even go to the pool last night.
Yeah, you're right. You get struck by lightning.
If you open the first page of My Little Red Rules Book 2012, there's a letter from me. Wow.
And if you want, for limited time, she's going to sign
I
it
will also My Little Red Rules Book
16.99. Limited time.
Yeah!
She's got a little piece of paper.
Wait, come here. It's going to be a cluster,
It's a cluster
introduction.
Oh, I like that.
All right, here we go. John starts. All right.
You know, they say they save the best to last. They do. Right? Kathy Bennett is one of those lawyers who comes in here year after year and brings some of the best training to young lawyers and older lawyers like us that you'll ever see. So when they say the best to last, they do.
I've been knowing Kathy's work since I started training, seaman training, when I started as public defender, and I can say, because I'm sorry that we have to leave before Kathy's going to get finished because I'm going to miss out a lot, but she's going to send it to me, so I'll get to catch up.
That's really motivational.
What did you say about Kathy?
Really good. Yeah.
Kathy not only is such a wonderful teacher, but I think what really sets her apart is just how wonderfully supportive she is. She really, if you've been in her groups, you know how she takes care of you. She is always available for any gonna dig here, whether you call her, you gotta find her, but if you find her, you won't be disappointed. And it's also for us as faculty, because we look to her for the leadership that we need and to grow as trainers and as people.
You know, when you stand up here and give an introduction, you think, well, what is the most prominent thing you want to talk about that person? And Sean really stole it, because Kathy is one of the, criminal defense attorneys, but not always nice. I mean, genuinely nice. I mean, like, right here nice. We are cool, we are wild, we certainly are egotistical. Certainly are, yeah. But there are very, very few of us are genuinely and completely and totally, genuinely, completely, and totally. What is that? Trilogy. You'll remember that. Genuinely and completely and totally nice. And Kathy is the kindest, nicest. Give me a third. Give me a trilogy on that. Kindest, nicest, sweetest person that you could possibly know.
Wow, that's really hard to follow, so I'll just speak the truth. Of all the faculty this week and all the ones you'll meet next week, Kathy.
One more time,
Has
baby.
classier underwear. Cutting
You weren't
edge,
supposed to share.
sexy, frilly, but strong. It's the total package of drawers. So she really is a phenomenal trainer. She's
Where's the
taught
book?
all of us so much.
That's what it sounds like.
And she's about to teach you so much once the technology fucking gets together.
Yeah. Samuel L. Jackson was gonna make an appearance. I'm not so sure if he's going to do that.
Oh.
Thank you, everybody.
All right.
All right.
Bart can speak.
Thanks, everybody.
I was going to say, here's Kathy.
Oh, really? Now, I said to you the other day, you feel the love in the room, right? Because these people have my back. I forgot my remote control. I had to go back and get it. I'm fat and out of shape, so now I'm out of breath. Okay. And yet, here we are together in this place to talk about our very favorite part of the trial, right? Direct examination. So, direct examination, what can you say about that? When I was a new lawyer, I was a particularly arrogant fuck. And I would watch prosecutors get up and do their cases, and I would see them use this brilliant trilogy. It would go something like this. What happened? What happened next? And this is the clincher, okay? This is where it really all comes together. What, if anything, happened after that? So being the arrogant person that I was, who, by the way, had not taken trial advocacy when I was in law school, I thought direct examination was a walk in the park. After all, who can't say what happened next, right? And then I had my first Superior Court trial, and Mrs. Lannister knew that my client Bruce could not have been the one who knocked this poor little old lady over and stole her purse, because he was actually in Springfield about an hour before the robbery happened. And Springfield, if you're from Massachusetts, is just not close enough to get from a dentist's office there to downtown Boston to do a robbery. And so, I was going to call this witness, and I have to say, that it was one of the most painful experiences of my life. I was prepared, I had prepared her, I had documents, I was ready to go. And it turned out that direct examination was a bit harder for me than cross-examination. I mean, after all, one of the things we really worry about, right, is making it so unbelievably, painfully boring that people slip into a coma. Or we could do a direct that is really incredibly exciting, right? There's our witness, running down that hill, full speed ahead, collision ahead. She does not look equipped to deal with what's going on. Right? And I'm not sure if that's her or me right there, right? We're all kind of feeling that thing together. You know, we think we're on the same page, but sometimes we just try too hard, you know? You know what I mean? You know, and the thing is that what winds up happening sometimes when we're trying too hard and we prepare too hard is it winds up looking rehearsed and stale and like a lie when it's not. Then there are those times where things just fucking happen. Like Samuel Jackson will not play on your computer after you fund him, okay? And those are painful, right? And in the end, this is how you feel, right? What the fuck was I thinking, right? The house is afire. What the hell am I going to do? How do I mitigate the damage? Because after all, right, the benefit of being the criminal defense in the case is that we do not have a burden of proof, right? The burden of proof is on them. And we sometimes realize that the minute we put up a real crucial witness in our case, that burden of proof begins to shift to us. And we lose the advantage because the jurors start doing things, right? Despite what we say to them about how that's not supposed to happen. And so, it's just a decision in the case and a process in the trial that's very challenging for us. And so, really what it all comes down to, right? The control problem, right? Because when we're on cross, we are the source of the facts, we are using inflection, we have the power of life or death over that witness, right? We can box them into a corner, we can coax them into thinking we think they're the best things in sliced bread so that they go along with us, only to be decimated by us in closing argument, and on and on and on. And direct examination is just very different. It's a different kind of control that you have to learn to create in direct examination. That's what we're going to talk about some today. But before we get there, let's just talk about, so why would I put that poor lady on the sled and me, and let's just say my client, through this thing, right? Well, the first thing, right, is theory of the case. Some of you may recognize the people in this slide. That tells me that you are awesome and you have terrible taste in TV. I'm addicted to The Walking Dead, okay? And this guy here in front, Daryl, he's got a crossbow. They are walking through the jungle because there are literally dead bodies, animated, all around them, trying to kill them and turn them into zombies, which they really don't want to have happen. And they have to be really quiet, because if they're not quiet, if they fire a gun, if they make too loud a noise, the zombies wake up and march towards them inexorably, en masse, in numbers too great to defeat. So Daryl's out in front, and he's got that crossbow, and they're being quiet, and they're being stealthy, and they're being smart. Daryl is walking point. And that's what our theory of the case does for us. Theory walks point. Theory tells us when we may need to put some witness on, when we may need to put some evidence on. That's what gets us there. And I want to pause for one moment, because I have the sense sometimes, well, I know that this is how I used to think of things, that when we think about cross-examination, we sometimes think of it as we're going to get up, and we're going to poke some holes, and we're going to show doubt, and we're going to bring people down and show weaknesses in the other side, in the prosecution's case, right? And certainly there is that piece to cross-examination, but you all know from all the stuff you were working on yesterday that there's another piece to cross-examination, which is the affirmative piece, which is bringing out facts that help us, right? And ultimately, what we do on cross-examination is we assume a burden of proof. We mentally agree and contract with ourselves and with the jury, though unspoken, I would recommend, that we are going to prove our case through their witnesses, right? And so when we think about this, do I put on evidence? We're talking about the direct case now, our case in chief, which is just a continuation of what we've done before. Okay? And quite frankly, the fact that we may talk to a witness, whether it's our client or our client's family or someone else, the fact that they may be telling the truth is just not enough to justify putting them on, right? Because if we put them on and they have baggage, or they have information that the other side knows that also weakens our case, while at the same time they have stuff that helps us, it's problematic. If they have a record that's going to, and we need the jury to believe this person, if they have a criminal record that's going to come in, that's going to cause the jury to doubt who they are and the truth that they're telling, and we don't have another way to help show that they are credible and that they have a reason to be telling the truth, and that there are other things that we can point to that show that they're telling the truth, it's a mistake, even though, or it can be a mistake, even though we know they're telling the truth. We have this whole self-fulfilling bullshit line of excuses as criminal defense lawyers, and these are the kinds of things that I really want to caution you against getting into. If you say in general, right, jurors really need to hear from the client in this kind of case, because I represent James Brown and he's charged with rape, and in order for the jury to see consent, I need to put him on. Well, if the law of your jurisdiction is that the Commonwealth or the prosecution has to disprove consent, right, beyond a reasonable doubt, if it is not an affirmative defense for which you have a burden of proof, then you can do it through cross-examination. And I think we all began to see yesterday, when we started to really work on the fall training cross, that there's a lot to work with. So we don't necessarily, in this kind of case, need to call a witness. We need to figure out whether or not in this case there's some piece that only our client or this witness can help us with to ultimately answer the major question, which is a why question, right? You know, I never put right? Just don't do that. I don't call witnesses, right? That's horseshit. My client just could not be believed because he's got a record, right, and he stutters. Or my client just won't testify believably. Well, how the hell do you know unless you try? With this client, okay, the jury will hear about his record. Bullshit, right? In James Brown, what are you going to do if you're going to call him? You are lawyers now. Use the stuff they gave you in law school. What are you going to do? Motion in limine. You're going to motion in limine about what?
Prior bad acts.
Well, right, the prior bad acts, which are criminal convictions, right? So we're gonna move to exclude them because they're not probative, right? And it's unfairly, as Miranda was talking about today, unfairly prejudicial. We're also gonna probably move and eliminate to keep that sex tattoo from coming into evidence. You know, I'm not real happy about that, right? But until I file a motion, right, and have a hearing, I don't know if that stuff is coming in. Okay? So, file a motion and have a hearing. So the pros and the cons, all right? The cons, we look at, we all know, burden shift is their criminal record. We know that the prosecutor's going to get to cross-examine this person, right? The witness could freeze up, and despite being truthful, because of the kind of person they are and the amount of fear they have, perhaps other things going on with the witness, they may freeze up and look like they're lying, even though they're telling the truth. And of course, the pros are that we get to introduce evidence and testimony, right? We get to explain evidence. Sometimes we get to impeach their case or corroborate the defense facts that we've brought up. I really hate that phrase, humanize your client, okay? It should be personalize your client and our case and our theory. And ultimately, we come back to theory. It's about advancing our theory of the case. One of the things I really will take into consideration before deciding whether or not to put a witness on the stand is who is the prosecutor. There are some prosecutors who are born cross-examiners. I don't know how it happened, because I never did defense work at all. And I'm thinking of a guy named Eddie Burns in Suffolk County who was a devastatingly effective cross-examiner, despite the fact that he had no idea what the witness was going to say before they got on the stand. It was unnerving. And so, if Eddie was on the case, it was going to take an awful lot for me to put that witness on. Okay? But the thing is, it's way too late to start making these decisions, and we all know this, right? When the Commonwealth threats. This is stuff we've got to figure out before, right? Okay? So, we need to think about it, we need to plan for it, we need to strategize and prepare early. And we're going to be using our legal acumen and skill. In our motion practice, we're going to be using our hearts and our minds and our guts to think about our theory of the case, the emotional and factual dynamics of the case in theory of the case that we heard about so beautifully on the first day of the course from Andrea, okay? The preparation of the witness begins when we begin to have a relationship, when we meet them, okay? And ultimately, the better your relationship, the better the testimony is going to be, because the testimony will be as good as the relationship in most cases. And of course, that's especially true of your client. That begins when you meet your client. So in thinking about whether or not, I was asked to talk just a little bit about this, whether or not to put the client on. We think about our client. The client obviously gets to make the choice, okay? We have a duty and obligation to give the client our best advice from a legal and advocacy standpoint, trial advocacy standpoint, about what's going to be effective. But ultimately, you can't help the client make that decision until you've gone through the process of actually working on a direct with them, to see whether or not this person can handle it. And that's not a one-time deal. And when you are thinking about this kind of thing, you want to think about, and we'll talk about how to structure it and how to construct it and all of that stuff in a moment. But really what you want to do is you want to help the witness. Now, if you are helping the witness with language during preparation, right, is that suborning perjury? Okay, nobody gets to go into a coma. I know you're hungover. I'm brutally disappointed that I'm not. So I have no excuse, and it's hot. So, really, what the hell did I just say? Right?
Not
Right?
unless you're changing the content, I think.
Okay, not unless they're changing the content. Now, remember Sean, when he talked about client interview, right? And client relationships. He talked about that process that sometimes we go through where a client's story will change over time as they come to trust us more and they learn more about the case. Does that mean that the first version was true, the second version is different, and therefore we can't put them on?
No.
No, of course not, right? And so, one of the things that you'll be thinking about in counseling a client on is whether or not what they say now is believable, whether it's credible, whether you can corroborate it with other kinds of evidence, especially if it's evidence that comes from the Commonwealth's case or prosecution's case. And those are the kinds of things that you'll think about. But the mere fact of a change in story, you know, is step back and ask why the change has happened. You know, most of the time in my experience with my clients, it's not about perjury. Sometimes, though, it is about fear and thinking that if they just tell a better story and they exaggerate some, that will help them. And the best way to help a client realize that that's a bad idea is to have someone other than you, if at all possible, cross-examine them. And that will help them see why it's a bad idea. Because in the end, and this is not a thing about suborning perjury, but in the end, I just want to know that it's going to be effective. If it's not going to be effective, I'm not putting it on. Okay? If I can get them to agree, which I hope I'll be able to show them. So preparation is the be-all, okay, of direct examination. It's a different kind of preparation that we do. The investigation, the interviews, the scene visits, the photos. If you can go to various scenes with your witness that are involved in the case, that's enormously helpful. If not, photographs and diagrams are key, right? The witnesses' relationships are really important, okay? Not just their relationship to your client, which is kind of obvious, if there is one, but the relationship with your client's family, or your client's friends, or your client's, what was the word, where is it? That he used the other day was affiliation, you're affiliated with him, the affiliations, okay? But also, the complainant, and the Commonwealth, the prosecution witnesses, and the police. It's really important to find out if they've ever spoken to the police. It's really important to find out what is their basis of knowledge. Because I've gotten grand jury transcripts where the prosecutor put a witness in and tells this whole story of what supposedly happened in the case. Come to find out 2 months later when we're talking to him that he had absolutely no personal knowledge. It was all the word on the street, and he told a great story, and the prosecutor never bothered to find out how he knew, right? And I swear to God, you read the transcript, you thought the guy was there. So what's the basis of knowledge? But what you're doing and thinking about all of this is you're thinking about ways in which the prosecution can come back and undermine your witness's credibility or reliability. Because they may have access to information that you don't have access to because you did not ask the right questions. So think broadly about this. This is an important thing. Okay? Find out if they're talking to your client. Find out if it's a domestic case, right? Find out if they're visiting a client and putting money in the canteen or accepting collect calls or writing letters, all this kind of stuff, really, really important. Okay? Enough said on that. We've all experienced the pain of the jail recordings, right? But has this person ever been arrested with our client? Because suddenly, even if it's not a conviction, the prosecutor may try to get into it if we don't know about it. And get into it because they'll say that it's relevant to bias, right? An association, bias against the police and for our client. So think carefully about these. But ultimately, you ask yourself at the core level, why do I want to call this witness? Why do I think this would be helpful? How specifically will it be helpful? And this is where your thing comes in that Lorinda talked about the other day when she and Jeff were talking about storytelling. The evidence checklist, the fact checklist. So what are all the facts that I know this witness can give me that maybe I haven't gotten from the prosecutor's case. Or maybe I have, and now I'm using their case to corroborate my case, and my case to corroborate the parts of their case I like, right? But what is the evidence checklist? What are the facts? What are the background? What's the backstory? What's the emotion? What do I want jurors to feel about this witness? Right? That's what you're thinking about. And ask yourself, what is it about what this witness says that makes you believe them? That makes you believe they'll be credible? So, Terry's not here today, at least as of now. And so I get to say, yesterday, or whenever it was, he talked about cross-examination in front of the word ethos. I'm a big fan of the word ethos. Because I think the word ethos is about character and integrity and credibility, okay? And so I'm thinking about the ethos, the credibility, the character, the integrity. Not that I'm going to put on character witness evidence, but of this witness. Is this person someone whom the jury will see as credible? Is there an integrity in them and in what they have to say? And that's something that I think is really important to consider. The other pieces of that, right, is when we think about anytime we have to make a really important decision in our lives, and we're having to rely on one person to guide us, whether we're going to do it or not, we begin to think, who is this person? What's their stake in the decision that I'm going to make? Are they going to make money or are they going to lose something? What's their track record? Is this a person who other people seem to accept as being true? Have they been credible? Have they acted honestly in the past, right? Does this witness, as sincere and honest as they may be, pure of heart and all of that, right? Do they actually know what the hell they're talking about? Are they confident? Are they reliable? Is the information that they have reliable? That's the kind of stuff we're going to be thinking through. What makes me believe this person? And the reason you're thinking this through is not just to make the decision about whether or not to give up the burden of proof and call this witness and advance your theory of the case and all of that good stuff. The reason you're also thinking about this is because it will have a direct effect on how you structure the direct examination and the types of things you choose to spend time on. The places where in scene setting and movie making, right, in the storytelling where we zoom really in close on Lila, or maybe we back out and we don't spend quite as much on that piece of it, right? So that's why this stuff is really important. And as we prepare to call the witness, we're going to think about now, what is the witness's story? What is the factual story, right? We think in facts, but we're trying really to reorient ourselves, shift our brains into thinking about facts are really represent scenes and events and places and people and action. Cases are not about facts, they're about people, and they're about relationships a lot of the time. So, we're thinking about the facts and the scenes of the story that go with what this witness has to say. And we think of these scenes in some ways as building blocks. If you're a rational thinker, which we all are, we all want to use that logical part of ourselves, which is the other part of Aristotle's trilogy of ethos and logos. So the logic and the factual basis. And we think about what they have to say and how we might arrange them so that they will be as strong and as impervious to the mighty, blustering wind of the prosecution's cross-examination, right? And we think about the scenes that those facts represent. We do our storyboarding. Now the reason, I think we kind of blew through this the other day, so I want to take 1 minute to talk about this. The reason we do the storyboarding in this way is for two reasons. One is that it helps us, by having these separate scenes, it helps us think about what order we want to do things in that's going to be the easiest to understand and the most persuasive, right? The other reason we do it is because when we start trying to draw the picture as pitiful as we are, as artists, me, some of you are good, it's awful, stick figures, really. But the minute we start doing that, we realize that we have a stick figure and another stick figure, and the rest of the page is blank. And then we're thinking, well, where was this? And then we think where it is, and we start to draw the details that maybe it's a street corner. And then we think about, well, was it night or day? We think about who was there. Was it busy? Was it crowded? What was the scene like? And we start to fill in the details so that we go from stick figures to having a full picture. Like, if I tried to draw the Darrow walking point, I would have started with a stick figure with a bow, maybe with a bow in his hand. Okay? But by the time we're done, you have that picture. See what I'm saying? So that's why scene setting, why this is important, because narrative detail is what makes the story come to life. The other thing about narrative detail is, has anybody in this room ever had to testify in court? And how'd that go for you? And literally, did anybody have a really good experience? Not one, really? God, it's awful, right? Holy shit, it's awful. Because you are in control. And we love to be in control. And we wind up, if the person who called us, which was my experience the first time I testified, it was like, I'm gonna ask you about what happened when the police officer and the DA told your client that he could have the deal. And then he informed, and then they pulled the deal from the table, right? So it was a motion, and it was all about detrimental reliance, but I was there to talk about the deal, what had happened, what led up to it. So I knew that's what I was testifying about. That was it. And that whole, what happened, where were you, all of this stuff, we got off the same page so quickly that it was beyond belief. So then I'm trying to make up for it, and I'm in front of this asshole judge who starts screaming at me to stop being an advocate and know that I'm there as a witness. It was miserable. It was awful. It was stressful. So there are things that we can do to help keep that kind of thing from happening. And when we think in scenes and we think in narrative detail, what that does is it takes the witness to, ready for this? You probably heard this in your groups, sense memory. It puts them back in the place. And now it's much easier for them to know where we're going and what we're doing and what we're talking about, if we ask questions that help elicit those narrative details. But that takes preparation, okay? So narrative details are really, really persuasive. And I may forget to say this a little bit later, so I want to say it now. When you have a witness on the stand who has, and you're getting to the thing that's most important, and let's say they're a fact witness who saw something, good, right? For your case at least, if not good, in the moral sense. Shift into present tense. So it might be, let's say that for some reason the government doesn't call Mrs. Olson, but I decide I want to call her because I decide I do, right? And I want to talk about the moment that Paula shows up in the doorway of the laundry room, not in her office, but in the laundry room. So, Mrs. Olson, you're in the laundry room, 10 o'clock in the morning, Cal is with you, right? Those are leading questions. So the way you fix that is, where are you? Who is with you? What's going on? What can you hear? What do you see? What happens next? When Paula steps into the doorway, what do you see? So that first person I mean, so that that present tense stuff comes to life. And that really glues the witness to the sense memory, because they really are reliving it right now. It makes their testimony so credible and so compelling. But you gotta be patient, and you gotta commit to the present tense phrasing of the questions. So as y'all see about this technique about avoiding leading, I think about the leading statement that I might make, right? And then I put a what on the beginning of it, really, right? Okay. So, the narrative detail is powerful, and we know from Jeff's talk on storytelling about brain science, but we also know this from history and from storytelling and from our own lives as human beings, that what we like best and pay most attention to are things that are vivid, to images, colors, smells, taste, touch, positions. That pause for the brown case. But positions in the interrogation room, right? Emotions to flat text or spoken word. Okay? That's what the brain pays attention to. So we want a structure so that we are getting to all that stuff. And I'm thinking now, in addition to the basic story, I'm now thinking about what are the pieces of this story that I'm going to build in the storyboard somewhere, that there are facts that I brought out on cross-examination that I'm going to repeat through this witness, because this witness is going to testify consistently with those facts, and I'm going to bolster the credibility of the facts both ways. But I'm also, what I'm doing is I'm backdoor corroborating and supporting the credibility of my witness through facts that they have and that they've given us, right? Makes the testimony more powerful. So be an opportunist. Look for those opportunities in your case, even if it isn't strictly within the story, the total storyline that you're going to tell. Thinking about structuring the story, right? We've been hearing about primacy and recency. Primacy, as you will recall, is something that people remember best, but that's not actually the most important piece of it. Primacy establishes the lens through which the jury will see the rest of the story. There is a reason that Karen chose to start yesterday with the marriage vows. There is a reason that I saw people all day long doing crosses of Otero, where they started with his pending case. Not with any of the horse shit that, by the way, didn't happen in this case. How do you cross about stuff that didn't happen, right? But we start with the pending case. We start with the fact that he's out of work. We start with those things because they establish motive. And now, when we impeach other parts of the story that make no sense through the cross-examination, right? In the cross we're talking about now, it's much easier for the jury to understand why they're not going to believe the guy, because they've got the lens, the primacy lens. Well, the same thing is true in direct examination. And sometimes that's going to be accrediting your witness in detail, but not always. So think about what that primacy is going to be within the structure of the examination of the story you want to tell. How do you handle the examinations? the introductions. If you guys, on Monday, if I get a text from any of my buddies saying that somebody got up and said, could you please tell the jury your name and spell your last name for the court reporter, I will personally fly back and kick the shit out of you. That is not effective stuff. And there's no excuse for it, right? There's a reason we think direct is boring, and that's because we've had to see a lot of really boring directs from prosecutors. And we've learned from them, which is why we say things like, what if anything happened next? Did you have occasion? What the hell, right? We don't talk like that. Do we? We say no, right? So, there's no excuse for us to be boring and to be stilted. We want to bring our humanity into this thing, which is going to set us apart from the DAs. And by the way, the DAs who do really good direct examination, go watch them and learn from them. You will learn some good stuff from watching a good prosecutor do a good direct examination. We're going to be thinking about the scenes, which we've talked about, and when we're thinking about the key scenes, we're thinking about the key moments, right? We're thinking about the why questions. When we're calling a witness, there's an additional type of why question. There's the why question in the case, or why questions in the case. And then there are the why should I believe and accept this witness as a source of facts and as a source of information. Does that make sense? Okay. So we're thinking about both of those levels, and we're thinking about the story of the trial. The direct examination of your client does not start when you say, the defense calls James Brown, or the defense calls Lorenzo Bennett. When does it start? I'm sorry?
When they first see him?
That's right. The very first moment of jury selection. Because do you remember what Jeff said, or somebody said about how much information is conveyed through nonverbal communication? How much are we storytelling about our client in the way that we interact with the jury through the whole trial? Do we sit, client's here, client's there, and I'm here, right? And the jury's here, do I sit like this through the whole thing? And cross my legs this way? I mean, those kinds of nonverbal things convey a lot. And it's funny, you can conduct a direct examination without your client ever taking a stand. All right, that's an exaggeration. But the thing is, right, but the thing is, that is where all of this starts. Being aware of the dynamics and the scenes that we are creating, because that's part of the story of the trial. Right? Part of the story of the trial that the jurors are witnessing for themselves. And by the way, the things they see for themselves, they own a lot more. Because they trust their own eyes and ears and instincts and guts and emotional leanings more than what other people tell them from past events they have no information about. So we're thinking about the scenes, and we're thinking about recency. How do we want to end this thing? And I always think about sticking the landing. Everybody remember Kelly, what's her face, from the gymnast who had sprained her ankle, and she's in the Olympics, and she does the horse, and she flies over, and she's in agony, and she lands, and she comes down like this, and you can just tell it's killing her. And she holds it, and she pulls it up, and she does that ridiculous thing they do when they oh my God, I need a surgeon now, right? But anyway, but the thing is, you want to stick the landing. You want to end on a solid place. So you have to have your exit strategy in place for something that's going to be strong, something that might be a little bit emotional. And the way you end is by shutting the fuck up. Stop. Stand in silence. Attorney McCarthy. Thank you. And then go sit down, because they can't start questioning until you do, and you get to hold the moment a little longer. Not in a fake way, not artifice, not John Lovett, Master Thespian way, right? But in a real way. Okay? The thing about this thing is you cannot hide from the bad facts. So if there's, quote, the bad facts, if there's stuff that you know they have against your witness that weakens the story, do not pretend it doesn't exist. Bury it in the middle. Because that way the prosecutor doesn't get to do what we love to do, which is get up and immediately kick the shit out of the witness, where both the witness and we lose either credibility or competency points with the jury because we've hidden something. Okay? So let it out there. It takes the sting away. But put it in the middle. In preparing the witness, sometimes, if you're rushed, and you don't have as much time, and sometimes even if you're not, we just love to cross-examine. I swear to God, a few minutes ago when I was doing I made it about do the leading question, which I was planning to talk about here today. But I made it about do the leading question, then turn it into an open-ended question, what, when, where, why, how, who, explain, describe, right? But that's not the truth. What happened was I started cross-examining. It's automatic, right? So if you prepare your witness using leading questions, of course they're not going to be able to follow you. And you're going to get objected to. You're not going to be able to switch up and do it through open-ended questions. questions. So make yourself prepared using the open-ended questions. They're not hard, right? What, where, when, why, how, describe, explain. And what I like to think about, I tend to think visually. And so if the moment in time is there on the floor in the middle, and that's what I want to describe, I think about that being in the middle, and on the periphery, walking around it, looking from different angles, in different levels, are the who is there, what was happening, what time was it, when stuff was happening, how it was happening, breaking it down into what I'm going to hope to accomplish on something important is to baby step through the scene the way we were working on doing cross-examination, and I'm going to be able to do that with open-ended questions. Now, how do I get to do that? The way you get to do that is through the technique of looping. So the witness gives you the answer that you like, and now you can take that answer and loop it into your next question. So when you saw her standing in the door, what did you first notice? And when you saw her standing in the door crying, what did you do? Now that might not be the scene image I want, because we talked about this in my group yesterday. I'd rather have her talking about how her clothes weren't torn, and you know, she wasn't bleeding and looked okay, right? But upset. So I would probably invert the order, but that's something I can talk with my witness about and prepare them for. Because the thing about preparing in scenes, with the witness as well as for you in thinking about how you want to tell the story, when you then go through the preparation and the rehearsal with the witness, you're doing it in scenes, they understand the order you're going in, and they can do better. Now, a couple of things to help your witness, okay? Number one is explain to them why you're calling them. And explain to them, particularly, you know, in cases where they're not carrying a load of facts, you know, if you've got, I've called witnesses to say that my client had a scar on his face 5 years ago, that it happened when he got, you know, I don't know, when he fell down the steps and had to get stitches, right? Because that's an important thing for me, because in an ID case, the witness never described a scar on the assailant's face, okay? It's a small fact, but I'm gonna call somebody to talk about how it happened, how long it's been there, and that it was there during the time when the robbery happened, whatever, okay? Let them know that they are not responsible for whether this is an up or a down, that they're one piece of an overall trial strategy. And they just need to do their part well and not exaggerate. Let them know how to handle cross-examination questions. Let them know not to get into stupid fights about, and to say yes when the answer is yes. And to resist the impulse to go yes, but, unless the prosecutor's cheating with the question. And that's something you can explain how you would do that in the context of this particular witness. Because you get to do redirect, and explain to them what that is. Explain to them and help them rehearse what to do when there's an objection. And what the word sustained and overruled means. Take them to the courtroom. You remember your first day as a lawyer, first day you walked into the courtroom, you'd never been there before? You remember that like frozen fright about where the fuck do I stand? Right? Okay? You can really help the witness by taking them into the courtroom and showing them the courtroom and having them sit in the chair and having them see from that perspective what the room looks like. Do it on the lunch break, do it at the end of the day. Help the witness by explaining what you want them to wear. Now this is important, okay? One of my favorite public defenders ever who taught me, I'm so lucky to have known Stephanie Page, who so many people in this room know. And she tells the story of her first trial, and her client was not going to testify, but there was a description of the robbery and what was the combat zone of Boston, and she told him to make sure that he looked nice for trial. The description of the assailant was a light-skinned black man wearing a lavender tuxedo You're the cummerbund. But, you know, apart from telling that funny story, right, there's also, people have different ideas of what dressing up is, you know, what that is for them. I think that if you have a young kid and, you know, and you dress him up in a suit and all of that, do it, if you're gonna put him in a suit with a tie, do it for a reason. If it's gonna make him look awkward and small and kind of, do it because that's what you want the jury to see. Not because you think the kid should wear a suit because that's respectful for the court. It should match with what you're gonna do. Which is why, I don't know if you guys remember the Menendez brothers killings and the trials in California. But these were rich kids. I mean, rich kids. And Leslie Abramson had those kids show up wearing cardigan sweaters every day. Very nicely, tastefully dressed, but totally softened their image by doing that. So be deliberate, have the witness show you what they're gonna wear. If it's your client, get together and figure out what they're gonna wear every day. And if you're in a public defender's office, you all know about the clothes closet, right? How much money have you spent on shoes that walk down to the courthouse at the end of the day? Okay? So that kind of stuff, all right? And you're gonna write out the question, the answers, write out the answers, and try to do it as one fact per question, because that will help you in breaking the scene down the way we did with cross-examination. And then when you write the answer, the fact questions, cross-examination type thing, then convert it to the open-ended, using the what, when, where, how. Now, once the witness has described something, you can then use soft leading questions without cheating, okay? Some people say that, was he black or was he white, or that kind of thing is a leading question. And it is sort of, but it doesn't call for a yes answer. It does suggest, but if those facts have already sort of been talked about, you're now asking a clarification question, that's not only appropriate, it's effective. Because you're helping the jury see it better, and helping the witness describe it better. Now, the other thing that will help your witnesses, in addition to the use of narrative detail, okay, is to bring in props and evidence. Think back to when John, during the opening statement demonstration, put up the first picture of Hope. And then put up Bonnie as a little girl. And then put her up as an 11-year-old girl. And then I think he had one of her as a 15-year-old girl. Okay? That stuff is really powerful. And so if you're struggling with painting a scene, and it can take, I mean, it can get really bogged down. Make it easy on yourself. Have a photograph, have a map. Have them come down and start showing where shit is on the map. And don't do it again, just because the prosecution's already done it, and you're happy with that picture, unless it's gonna help the jury understand what the witness is saying, don't have them do it over again, that's boring, right? Only the pieces that are gonna help you. And so, those kinds of things really make it much easier on the witness, because you're saying, who is this in this photograph? Really, how long had you known him? Blah, 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 you know, that kind of stuff. The same with scenes, the same with demonstrative evidence. When you're describing action, now, do not have James come off the stand and act out. Okay? Do not. I'm just saying, don't, right? But maybe you have Lorenzo in the chair, right? Maybe you have Mario come down and describe where they were sitting in the bar and what was happening by having him come off the stand and sit there and put the chairs right around and create that scene, right? Have him testify from there. A guy named Keith Belzer won a case where his client was, it was a horrible case, and it was a civil case, a civil rights thing. But they had put this guy in isolation, he was mentally ill, and he completely decompensated and lost his mind. And it was despicable. And what he did for the direct examination was, public defenders, I hear your pain. He built a scale model of the cell. And so the back of it was opaque, right? The problem with drawing the little tape on the floor and putting the chair in the middle when you want to show it's really small is that there's no walls, people can see through it. They don't necessarily get the sense of how crowded it is until you start filling it up. But he had that with a high wall and then a lower wall down to this thing that like represented the wall so the jury could see in. And he had the client testify from there, his entire direct. And they won the largest verdict in Wisconsin history out of that case, on that kind of civil suit. So thinking about doing that, finding ways, using that 7-minute rule, that 10-minute rule, using the emotion and the color to get the witness off the stand, to demonstrate, to act things out, to show the jury real objects will help them tell the story. And it will help you tell the story, because it's a lot easier to do it that way. Show them the picture first, then have them describe what's in it. Then have the picture up there, and now we're in the scene, and now we can go, right? Okay. All right. That evidence checklist. This is what, I'm gonna tell you what I do, which is not necessarily what you do. I'm just gonna tell you what works for me. I write out the direct, I write out the answers, but I found when I wrote out the questions first, or even the answers with the questions under, you know, the what, where were you, when, blah, 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 that what would happen would be I would be stuck to a script in a way that I'm not stuck to a script in cross-examination, because I wasn't picturing scenes. I was so locked into the struggle of asking open-ended questions that I was forgetting to to do direct from the picture in my head and the picture in the witness's head. So, what I do that process to get into the open-ended thing, to get that into my body. But then what I do is I list the facts and the scenes and the key quote facts or emotions or whatever it is I'm looking for in the order I want to do it in. And that can be one word or a phrase, so that I know when I sit down, I haven't missed anything important. And that frees me to do the active listening. Because direct examination really is all about the conversation. Even yesterday, we were joking around in one of the groups I was in about how we're on cross and we've been kidding around about lawyer man, or I call it speaker man. I'm now going to ask you some questions. But if it's a conversational cross and somebody we're not trying to beat up on, right? We don't talk that way, even though we don't know the next word that's coming in our head necessarily. We're not looking at the ceiling and doing this kind of shit when we're sitting out by the pool, right? Right, Pete?
Right.
It's true, right?
Absolutely.
We're like, I'm looking at Lila, I have no idea what I'm gonna say next. And I really should wrap it up because you guys have been very patient, it's very warm, and you're all hungover. So, but I'm like, I can do this and look at her. And when I'm looking at her and she's looking back at me, it makes it a lot harder for me to speak in the legal formalisms that fuck us up. And fuck our persuasiveness up, our human stuff. So, eye connection with your witness. The last thing I want to talk to you about in terms of the presentation piece is, on cross-examination, some of you may have heard the tip that we learned from actors, which is cheat your body 1/4 turn, your feet 1/4 turn towards the audience, your jury, and keep your focus on the witness. And so you want to be moving, you want the focus on you because you are the source of the facts, it's all about you. Direct examination is exactly the opposite. So what I suggest you do, and what I've learned to make work for me, is, and I'm even okay with having a podium there, tool of the devil most of the time, okay? But I'm okay with hiding behind a podium now because it ain't about me, it's about my witness. And all I am really doing is, in the words of Bernie Lewis, is that I'm facilitating a conversation between the witness, who has the facts and the information, and the jury, who needs to hear them. So I set up here, if this is the jury room, slightly behind, if I'm able to, the last juror here, which forces then the witness to look across at me, right? And now it's not them doing the FBI thing of, yes, counsel, and then answering the question. Yes, that's correct, ma'am, blah, 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 blah. You know, which just looks fake and artificial, right? They look like the painting. So now it's a much more natural thing, okay? The other thing that standing here gets me, does for me, is that it lets me know that I cannot hear that witness, then my jurors can't hear them. So I can have the witness speak up and slow down. The last thing is this, on the presentation of it. It's really hard sometimes to use inflection in a powerful way when all you're saying is, what happened after you saw her in the doorway? And the thing that can happen to us on direct is, by the way, when you do those facts and you finish them, do not be like, you know how DAs who do this shit? Like they're standing there doing that, checking them off as they go around. Do not do that, okay? But it's hard for me to have the inflection. What sometimes winds up happening is the inflection looks the same every time. And what happened after you saw her in the doorway? What happened after she walked in? What happened when you got to the office? What happened when you did? Which is not the impact word in that question, right? Sometimes the impact word is next because we're interested in sequence. Sometimes it's what happened, and if we're looping, that gives us more facts and something to hang on to use our voice and use our inflection. So we want to think about using that kind of, we want to think about, intentionally about using inflection. Try really hard not to be surprised by your witness. I think when you sound surprised, that sounds, because you're hearing something that you think will surprise the jury, you sound fake, it just sounds artificial. And if you sound really surprised, because you are really surprised, it's not a good thing. When that happens, right? Do not go into the, right? I think you could ask any lawyer who's tried more than one or two cases and done a direct examination that has happened at some point. And it's, never let them see you sweat. I'm in control. I might even stand up and illustrate it. That's because I'm, never mind. And I might walk in silence, I might turn and walk back. While I'm thinking to myself, what the fuck just happened? How do I fix it, right? And then you have a minute to deal with it and deal with it. But don't let the jury see the things you're not normally wanting to do. And so I'm going to flip through. Active listening, very important, which gives you that grounding. The eye connection with your witness gives you that grounding. Out by the pool versus in the courtroom, remember that, picture that, okay? The thing is, I think this is hilarious that Mae West said this. I just love this quote, right? The direct examination is only going to happen once. But if you do it right, it will be enough. It will be enough to carry the day for you. It will be enough for that witness to succeed. And you are measuring success in this situation not on the basis of what you did, but on the basis of what you allowed and facilitated and empowered the witness to do. If you prepare and you rehearse and you are careful about scenes and narrative detail, it will be successful. It will be. I like that quote because it reminds me too that we are all here in this place together, in this place of communion and spirit for our clients and for one another. Every time you get up to do a cross-examination or an opening statement, you put yourselves on the line. You just do. And it's risky. And there's a feeling of safety here this week for which I cannot tell you how grateful I am to have been here to feel it with all of you and to be a part of it with all of you. Use your time here next week well. Have fun. Share your experiences. Show up for group ready to learn something based on something you've thought about and prepared. This may be the only time you ever see the inside of Mercer Law School or ever set foot in Macon, Georgia. Make it count. I know that all of you have made it count for me this week, and I'm enormously grateful. Be well. Be safe.